Good day, everyone, and welcome to the semi-final match of the Hague University Law Debate Tournament of 2026. Today is the first of the two semi-final matches, so welcoming the participants representing the Jigme Singye Wangchuk School of Law, joining us from Bhutan, and participants as students of University of Nairobi, joining us from Kenya. So the topic for today's semifinal is whether or not states withdrawing from a treaty should remain subject to compliance review and responsibility for prior breaches. Of course, as always, before we find the positions for the debate, I would like to ask the students for the introductions, starting with the University of Nairobi, Mr. Irungu.
Good morning from Nairobi, Kenya. My name is Ian Hirungu, one of the participants from the University of Nairobi. I am in my fourth year of law school and looking forward to this debate today. Thank you very much.
Thank you and welcome. From Jigme Singye Wangchuk School of Law, Ms. Laden.
Hello, my name is Sonomigyeong Hadin. I am a third-year law student at the JSW School of Law, and I'm excited for today's match.
Thank you and welcome. Ms. Baraza of University of Nairobi.
Good morning, everyone. Good morning, everyone.
Yeah, sorry about that.
No worries, thank you. From Jigme Singye Wangchuk School of Law, Ms. Dema.
Hello everybody, I am Yuten Dema and I am a third-year law student here at the Jigme Singye Wangchuk School of Law in Bhutan. So I look forward to a great match ahead. Thank you.
You're welcome. From University of Nairobi, Mr. Kitui.
Yeah, I hope there's no echo. Hi guys. Okay, my name is Paul Kitui, University of Nairobi, fourth year. Excited to be here. Thank you.
Thank you. From Jigme Singye Wangchuk School of Law, Ms. Yangden.
Hello everyone, my name is Kile Yangdon and I'm a second-year law student here at Jigme Singye Wangchuk School of Law, and I'm also looking forward to a very wonderful match with you all. Thank you.
You're welcome. And also for acknowledging, we are aware the students have a supporting network, one of whom coach, a mentor for Jigme Singye Wangchuk School of Law is also present for this call, Mr. Tsering.
Hi everyone. I hope I'm audible. I would like to wish both teams all the best and we're looking forward to a great match. Thank you.
Thank you very much. So in a short while, you should be able to see for the position allocation and then of course countdown timer for your debates. If I can just get a confirmation that you do.
Yes.
Thank you very much. So 2 possibilities for each team. And we'll find that for today's debate, and in this first semifinal of 2026, it is the Jigme Singye Wangchuk School of Law team that will be defending in favored position. And thus, University of Nairobi will be defending the against position. You will now have 5 minutes to finalize your preparations. And I would also just like to, before we start, we will double check the echo for one of the teams. So feel free to close your cameras. Your 5 minutes start now. Thank you very much. Your time for final preparation has now passed. Before we proceed with the debate, just a short technical notes from our side. The timekeeping will be done by Mr. Sanchez Corses Macias. So once again, yellow for 30 seconds remaining and red for your speaking time being concluded. And I would also like to confirm there is no echo for any of the teams. So Mr. Kitui, can I just see if you have figured it out for your device, please? Can we test it, please? Can I just get an audio confirmation? Mr. Kitui or Ms. Baratza, can you please confirm with audio that your echo is
confirm that we can hear you. Our audio is okay now.
And there is no echo when there are speakers from their device?
Yes, if there's any echo, we'll just call out of one device and allow the other colleagues to speak.
All right. So on that note, without further ado, Jimmy Wangchuk School of Law, you have 4 minutes for your opening statement for the in favor position.
Am I audible and visible?
You are.
Thank you very much. Then I shall begin my opening statement for the motion in 3, 2, and 1. Esteemed judges and respected opponents, withdrawal ends future obligations, not responsibility for past breaches. Exit is a right, not an erasure. Before today's debate, let's clarify the very meaning of it with its two components. Firstly, a state invokes responsibility for treaty breaches, irrespective of withdrawal. And secondly, compliance review here stands as a preceding backward mechanism to scrutinize the conduct of these former member states to see if there were breaches or not. As such, we uphold the motion that withdrawing states should be subject to compliance review and accountability for past breaches. For this, we have 3 points. First, crystallization of responsibility. Second, pacta sunt servanda. And third, human rights obligations. First, responsibility crystallizes not at the time of withdrawal, but at the time of the act itself. Article 71b of the Vienna Convention on the Law of Treaties has said that upon lawful termination of a treaty, any rights, duties, or legal situations that were created before the termination of the treaty shall remain preserved. In the context of a breach, Article 13 of the Articles on Responsibility of States for Internationally Wrongful Acts confirms that as long as the obligation was in force at the time of the breach, you get responsibility for it, making subsequent withdrawal irrelevant. In the investment tribunal decisions of Carrizosa versus Colombia, the court held that when you breach a treaty, you get independent legal responsibility for it, making subsequent withdrawal irrelevant. Now, second, the pacta sunt servanda principle, exemplified in Article 26 of the VCLT, says that promises must be kept in good faith. This was stated by the court in Gabjakobo Nagimaro's case, where Hungary tried to run away, dressing up convenience as necessity from their treaty. Now, if you look at the very architecture of the VCLT, Article 18 and 65 prohibit you from breaking and destroying the treaty's purpose even on your way out. And procedural safeguards have been set up specifically because these drafters knew that you would look at exit as a way to escape. Your good faith obligations should not end the moment a withdrawal letter is signed. Now, third, these are not abstract principles at all. They are embedded in the world's most important treaty regimes. Article 65 of the European Convention on Human Rights states that denunciation of a treaty does not rid you of the responsibility you have incurred for prior breaches. Article 127.2 of the Rome Statute preserves the ICC's jurisdiction for prior conduct. And Article 33.2 of the RCWA allows individuals to seek restitution compensation for the wrongdoings done to them by these states that breached the treaty, regardless of withdrawal later on. When Philippines and Burundi withdrew from the ICC's jurisdiction, the Assembly of State Parties stated that we will still be looking into your prior conduct, and that is exemplified into a very proper treaty practice. All in all, We are not just talking about legal matters or procedural aspects. This is not merely a legal debate. It goes beyond that. It is a humane debate. Behind every breach treaty, there are countless survivors waiting for their justice. There are individuals waiting for their rights. And there are communities waiting for their compensation. Their suffering does not end the moment the state responsible for creating these wrongdoings said that, oh, we have signed the withdrawal letter, now we are out of the loop. No, we cannot stand for such regimes. We uphold the motion once again. Thank you.
Thank you very much. For the opening statement in the against position, University of Nairobi, 4 minutes.
Good morning once again, members of the panel. My time begins in 3, 2, 1, go. Now, members of the panel, proposition presents a compelling argument that a state should not be held excused from their prior obligations once they have withdrawn from the treaty. We do not object to this interpretation. However, members of the panel, the motion contains two distinct categories. First, that states should remain subject to compliance review mechanisms, and states should retain responsibility for prior breaches of the treaty obligations. These are two distinct categories, members of the panel. Now, while we understand that under the current regime, especially RCWA, Articles 1, 15, and 58, as well as Article 70 of the VCLT, states do retain responsibility for prior breaches of treaties and conventions while they were part of the treaty. We do not accede to the proposition by the proposition that they remain subject to compliance review mechanisms. This is because compliance review mechanisms are ongoing treaty performance that are not envisaged by the withdrawal from the treaty. To address proposition's arguments, first is the positive law argument. We understand VCLT Article 71 is the primary rule, and it releases states from further performance. The savings clause in Article 71 A and B, however, is narrowly tailored and read and does not entail or extend to ongoing compliance with review mechanisms, which are instruments of future performance and preserved past legal situations. Second is the consent jurisdiction argument. We understand that under international law, we have one, treaty-based international law, and on the other hand, customary international law. Now, customary international law applies regardless of a state's consent or subjection to a certain treaty. However, treaty law is based on consent between states. Now, no international institution has jurisdiction over a state that has not consented to it. Treaty bodies exercised derived and not inherent jurisdiction. So withdrawal terminates the consent that is a legal basis for that jurisdiction. Third is the lex specialis argument. We note that where treaty withdrawal clauses carefully define what survives, such as in the cases that the proposition has described, for example, Article 127 of the Rome Statute, as well as Article 58.2 of the European Convention on Human Rights. These are cases where the treaties themselves have specifically prescribed and expressly stated what the survival clause of the treaty is. It means that the default rule in international law is that withdrawal terminates all future compliance. Only in specified circumstances, for example, in Article 127 of the Rome Statute, where it prescribes that investigations and proceedings ongoing before the ICC will continue even post-withdrawal, as well as in Article 58.2 of the European Convention on Human Rights. It is only in such circumstances where these provisions have been expressly inscribed into the treaty that post-withdrawal compliance with review mechanisms and dispute resolution mechanisms is able to survive. In all other situations, any compliance with the treaty post-withdrawal is terminated because, again, members of the panel, treaty-based law is consent-based. It is contractual. It depends on the consent of the contracting parties to the treaty. Once that consent expires, an international body that does not exist independent of the independent of the consent of the parties cannot be allowed to operate. Lastly, members of the panel, there's also a systemic incentive argument. This is where any imposition of additional post-withdrawal obligations on a state will only serve to deter potential members from joining in treaties and conventions. This is because they understand that the incentives for staying in a treaty and the withdrawal from the treaty are the same. If a member state is subjected to the same compliance review obligations when they are in the treaty, and when they have exited the treaty, then it makes no difference to them. And therefore, they will choose not to join or not to remain in existing treaties. And this then frustrates the entire purpose of the international law multilateral system, because states will not be amenable to cooperating with other states. And therefore, members of the panel, this serves as our argument for the opposition. Thank you very much.
Thank you. This concludes the opening statements. Proceeding to rebuttal. For the first rebuttal in favor, Jigmesigny Wangchuk School of Law, 2 minutes.
Am I audible?
Yes.
Then I shall begin in 3, 2, 1. Honorable judges, 3 points for rebuttal. First, the opposition states that the debate statement presents 2 distinct issues, but they concede that prior breaches of responsibility must still be upheld. Yet they entirely avoid defending this point in their case. This is especially significant because the motion explicitly concerns both compliance reviews and prior breaches. By failing to address one half of the debate statement altogether, the opposition reveals a fundamental flaw in its argumentation. They selectively engage only with the issue of compliance review while neglecting the equally central issue of accountability for prior breaches. Second, the opposition leans on Article 71A of the VCLT and dresses compliance review up as further performance from which the withdrawing state is supposedly released. This reading is incomplete and legally wrong. Article 70 must be read as a whole. The opposition cannot wield 71A while pretending 71B does not exist on the same page. And the VCLT binds its 116 state parties, and ICJ has also repeatedly affirmed in Gavchikova Nagimaros that Article 70 reflects customary international law and therefore binds every state party or not. Lastly, the opposition claims that treaties are voluntary contracts between sovereigns, but we would like to question that. The ICJ in Gabčíkovo confronted this exact question. The reasoning of the court was that good faith forms an integral part of pacta sunt servanda, and that a party cannot invoke procedural mechanisms of treaty law to defeat the treaty's object and purpose. Sure, we agree that you can walk away, but we never agreed that you can rewrite history itself. If states could simply erase or diminish past violations via withdrawal, accountability becomes a dead letter. The court held the parties bound to negotiate in good faith, even after the treaty relationship had been disrupted. Thank you.
Thank you very much. For the first rebuttal in the against position, University of Nairobi.
Okay. 1 minute. Right. I'll start in 3, 2, 1. So just 2 factors to clarify. First is on the nature of compliance review, because we've been apparently called out on the separation of these 2 distinct features. So the first is to clarify the scope of compliance review. We agree that substantive obligations do exist. If a state has breached something, it's okay. So everything cited under Article 70 of RCY and the rest is fine. However, compliance review is broad and contains more than dispute resolution. If you look at most of the human rights conventions, it contains inspections, reporting mechanisms that go beyond the usual enforcing of obligations to a breach. So therefore, just enforcing the legitimacy of a compliance review, especially after the exit of a treaty, is probably not clear, as it may be a slippery slope to the extent within which you breach the sovereignty of any given state by enforcing a supernatural body, to impose laws on a state that wishes to opt out of an obligation. But even more importantly is to simply clarify our position as far as it goes with Article 26 of the VCLT. So we agree with the pacta sunt servanda principle on good faith. It's fine. However, as reiterated in our first submission, consent, as treaty fundamentally functions on a consent-based system, consent cannot be overridden by good faith. And additionally, a treaty ought to be interpreted in good faith is relative to the realization of the object and purpose of the treaty, which means that while we wish to enforce what the treaty may have provided, it's also the object and purpose of a treaty is also fundamentally anchored on a state wanting to be part of the treaty, and treaties fundamentally functions on consent. And therefore, in that regard, these obligations should not be placed on this treaty, primarily as the jurisdiction cannot be properly justified. Thank you.
Thank you. For the second rebuttal, Jigme Singh Wangchuk School of Law. Floor is yours.
Okay. Am I audible and visible?
You are.
Thank you very much. Then I shall begin my rebuttal in 3, 2, and 1. Esteemed judges, the opposition seems to believe that these compliance mechanisms are simply non-binding political tools, even accusing them of being encroaching upon a state's rights. But they have ignored one fundamental benefit that these tools provide. Without compliance review, withdrawal simply becomes a tool of impunity. A treaty is not a subscription service that you can cancel to avoid past bills. It is a solemn promise, and like any promise, what you did while it was in force matters. A state that wishes to commit or has already committed a serious breach can deliberately time its withdrawal to precede the conclusion of investigations or enforcement proceedings. Article 65 of the VCLT recognizes this danger in the most acute context, and because of this, the principle is buttressed by the Common Article 1 of the 4 Geneva Conventions and Article 41 of the RCWA as well. And moreover, the opposition has kind of forgotten that this is not merely an argument about jurisdiction, this is about timing. Your responsibility for the breach had already crystallized the moment you did the act. It was never about jurisdiction. If we continue arguing about procedural mechanisms, who is going to provide the justifications, the rights, and the compensation that the breached party has affected? The victims, the survivors, the communities, who is going to answer to them? This is not merely about procedure. This is about timing. And when you did the breach, that timing was already set. You got an individual legal responsibility for it. And as such, we do not agree with the opposition's point. In the name of a politically and diplomatically dressed up procedural mechanism, they are providing leeway for states to escape accountability and the enforcement of these treaties, weakening the very integrity of these treaty regimes. We rest our rebuttal here. Thank you.
Thank you. University of Nairobi, for second rebuttal. Floor is yours.
Just confirming if I'm audible.
Yes, you are.
Great. Starting my speech in 3, 2, 1. Members of the panel, as earlier introduced, we are not disputing the fact that states are to be held responsible for prior breaches. The problem arises when there is an absolute mandate for states to essentially be subjected to compliance review, especially at the point of being able to establish that a compliance review in itself is broad and it has not been definitively described by the motion in itself. But most importantly, all the examples that have been cited by team proposition, be it the Burundi case, be it the Philippine case, and even the European Convention, there have been specific provisions that have been created to allow the continued survival of the jurisdiction of the states. However, if you put it as a default mechanism where all treaties are expected to essentially align to that, it not only creates a fault, especially in Article 70 of the Vienna Convention, because note, it does not absolve states from prior obligations. However, it does not absolve states from prior obligations, but it releases them from further obligations. Looking at the characterization that has been fronted by both first and second opposition speaker, it's allowing compliance review, which not only includes reports and having all these mechanisms that are involved, it actively creates a slippery slope where this particular absolution from continuous or further obligations is still going to be enacted. And that the problem then becomes, it not only just creates a problem where states who are already like within these particular treaties are going to be bound further than the obligations that they already consented to, but most importantly, it's also going to create a situation where states do not feel like they can actively join these treaties in the first place because the substantive commitments that they essentially agreed to, they are not essentially being witnessed. But most importantly, at the point where that is going to be a default mechanism, it can lead to states essentially submitting to shallow substantive commitments, which essentially just makes the value of these treaties in the first place to not be as effective. Hence, it is important that states should remain subject to the prior violations that they had. However, when it comes to compliance review, if it was not agreed upon, it should not be a default mechanism that cannot sufficiently and legally backed within the treaties. Thank you.
Thank you. This concludes the rebuttal stage. Proceeding now to hear the concluding statements, starting with the in favor position, Jigmesingie Wangchuk School of Law.
I shall begin the closing in 3, 2, 1. Honorable judges, imagine surviving torture under a regime, finally finding the courage to seek justice, only to be told that the state has withdrawn. People's sufferings, their scars, their stolen years suddenly erased with a single signature on a withdrawal letter. Here, the opposition has built their entire case on a single move. They've taken the lawful right of withdrawal and tried to transform it into a legal eraser. But they're not the same thing, right? A state that exercises its right to withdraw from a treaty is doing something lawful. A state that uses that withdrawal to extinguish the legal consequences of wrongs it committed while bound. Now, that is something else entirely. Consider what the opposition's world looks like in practice. A state is under investigation for systematic torture. And then, before the final reckoning, the state withdraws. As per the opposition, those victims have no recourse to the treaty the government once accepted. Isn't that precisely what Burundi anticipated when it withdrew from the Rome Statute in 2017? The Assembly of State Parties refused to accept it, but the law does not work that way, and justice must not work that way as well. Article 71B of the VCLT and Article 13 of the RCWA make it clear. Responsibility crystallizes at the moment of breach, not at the moment of escape. The tribunal in Carrizosa versus Colombia confirmed this, and the ICJ in Gabčíkovo Nagimaros reminded us that pacta sunt servanda is not a switch states can flip off when obligations become inconvenient, right? And the ECHR, the American Convention, and the Rome Statute, all preserving jurisdiction over prior acts, is not a coincidence. It is customary international law telling us that exit ends membership, not accountability. So, honorable judges, we respectfully ask you to affirm that withdrawal is not an eraser for past wrongs and that accountability survives the exit. Thank you.
Thank you very much. For the concluding statements in the against position, University of Nairobi.
Members of the panel, my rebuttal begins in 3, 2, 1, go. Now, the scenarios presented by the proposition are inherently misleading. The position that is being taken by the opposition is not that accountability is erased by the pact of withdrawal from a certain treaty. It is that the withdrawal from the treaty imposes certain obligations on other states not to subject this state to compliance rule mechanisms that are broad and inherently indefensible. Now, for example, in the case of human rights violations, in the case of violations of international humanitarian law, such as have been cited in the Burundi case, again, the Rome Statute specifically provides under Article 127.2 that whenever investigations or proceedings have already commenced by the Office of the Prosecutor or the International Criminal Court with regards to violations of IHL, then these proceedings or investigations will continue even post-withdrawal. This means that the scenario envisaged by the proposition cannot occur because, again, Burundi would still be held liable, which was in fact the case because the ICC determined that Burundi would still be held liable for any IHL violations, war crimes, genocide that had been established prior to the withdrawal from the treaty. This means that already in existing treaty mechanisms, we do have provisions for states being held liable to dispute resolution mechanisms established by the treaties. What we are arguing as the opposition is that this cannot be a default rule in all situations and circumstances, since international law is much broader than simply human rights or international humanitarian law. It also constitutes international economic law, international investment law. This means that in every case, you need to scrutinize the exact treaty on which the dispute is based on and determine whether the right of withdrawal from that treaty also comprises the right of withdrawal from the dispute resolution mechanism. Compliance review is unnecessarily broad as a definition and therefore cannot be used as a basis to bind states to obligations that they had not consented to when they acceded to the treaty. This would have a chilling effect on the ability of states to enter into the multilateral system of international law and defeat the very objectives that proposition wants to protect. If a state does not join the Human Rights Treaty or an international criminal law treaty, will the interest of victims be protected either way? No. Therefore, we have to weigh in a cost-benefit analysis and determine that we should not impose obligations beyond what the treaty states and beyond what customary international law states. Thank you very much.
Thank you. Thank you. You can all now relax. This marks the end of your debate. This marks the end of the first semi-final of the tournament of this year. Congratulations on completing your match. I would like to thank you all for the execution of your arguments during this debate and for preparation. Really well done. I would also like to give the thanks for the 3 judges that perhaps already are now live observing the debate or will be observing shortly. As always, once we have confirmed the scores, we'll be sharing with you. And in a few days, you will be also receiving the topics for the finals that will be taking place on the 12th of June. The finals, which will be also live streamed and made available in hybrid format. So if the audience or your supporting networks would like to support you on the journey, whichever of the 2 matches you will be representing your university in, they will be able to see them as well virtually as well as in person. And once again, really well done for your semifinals debate. For the next part, which is the feedback and networking question, I will be passing the floor to Mr. Sanchez Cortez Macias, who will be wrapping us off throughout this session.
Thank you. First of all, congratulations for reaching the semifinals and for such an interesting debate. So, as you already know, I would like to collect your feedback on the topic research and match itself. So, I will first give the floor to the team from the Jigme Singwe Wangchuk School of Law.
Hello once again. So regarding this question, I would say that my first impression of this topic was that, oh, this topic is quite broad. Like maybe we can like look it from both ways. In a sense, like the particular part, like the prior breaches might have like kind of put a limitation on it. But apart from that, because the very concept of like treaty breaches and the accountability mechanisms for it are very broad, we were able to like look into a couple of like treaties and as well as the VCLT itself, which I think serves as the foundation for today. Overall, like these general principles, like as broad as they are like quite difficult to like quantify into a narrow like 4-minute or 2-minute statements. So all in all, it was challenging, but it was fun as well. Thank you.
Thank you very much. Now, I will give the floor to the team from the University of Nairobi. It will be just a team answer, so you can decide who wants to answer the question.
Okay, so with regard to the motion for today, I think it was really interesting because, again, I think the round is not being graded beyond the point of submission of our point. So I would say I was actually rooting for the proposition side because fundamentally I believe that the argument was like I just believe that the proposition's argument is much more logical, which is why I was looking forward to this debate because I wanted to see what the arguments raised would be. But it's a very interesting motion in terms of like our understanding of international law, what we think the international order should be, especially in terms of how the international law currently is deficient in terms of its gaps and failures. So this was a very interesting motion for us, and it cuts across a wide variety of international law fields. So it's not just about one specific aspect. So it covers human rights law, economic law, investment law. So it's just a question fundamentally how international obligations should be construed and how agreements between states should affect the rights of other participants in the international system, like for example, individuals and corporations. So yeah, it's a very interesting motion.
Thank you. And sorry, there has been a misunderstanding from my side. So from now on, I will give the floor to Ms. Obanova.
Sorry, just a technical glitch on my side. I will be also passing the floor back to the teams for the feedback. If you had perhaps in your during your debate some familiar arguments from your oppositions. So again, Ms. Dema, Ms. Yankton, or Ms. Ledden, in regards to your preparation and debate itself, how was the floor? How was the debate? And also if from the arguments from the opposing team.
Hello. So like Eden mentioned earlier, when we first looked at the debate statement, we thought it was a little broad, but I personally felt that it was a little more familiar than the ones that we've had so far, because almost all of the debate topics so far have been very technological driven. So this was quite reassuring to see, I guess you could say. But then once we delved even deeper into the debate statement and the arguments, we realized how these two features of the statements were two distinct components, and that was in a way a little challenging to reconcile, but we were able to do that. And today, I feel like the debate went well from both teams. I felt like my teammates did their best, and I felt like the other team did their best as well. Thank you.
Well, for our side, we'd say we have similar sentiments. So preparing for the motion was okay. From the face of it, the motion seemed quite simplistic, but then once you start delving deeper, you realize that there were two different components, as the former speaker has said, and it was more of trying to see what stance can be defended to its entirety. And I think that was a strategy that was adapted by both teams. Team Prop had their own stance and they defended it to the last bit. So did we. And I'd say it was a really nice team cohesion, especially from my team. We were able to have an alignment from the first speaker to the last. And I'd say there were quite some similarities, especially when it came to the case construction, because even the case law that they were referring on, they're not very different, but then you'd realize there were some, even though there was a prior holding, you'd find there was a dissenting opinion after. So it was just trying to see what particular aspect of a case fitted yours. And generally, we just say it was a nice round for us generally, and we are grateful for the experience. Totally. Yeah.
All right. Thank you very much. Of course, if you have any other feedback in regards to the debate execution, of course, you can also add it in regards to the networking question. I'll be posing the question now as well. This will be also individual. So if you have anyone you would like to acknowledge for the whole journey, and we know we had this question already in the previous debates when the wrap-up of the group phase happened. But we are now already on the 1st of June, so it has been even longer journey since then. On that part, if in one or two sentences, who would you like to thank for supporting your journey in this competition so far, and why has their support been so meaningful or impactful during these past months? So this one starting first with, Jigme Wangchuk School of Law, perhaps Ms. Dema.
So regarding our the people that we are grateful for, I would say that not much has changed, not because we didn't get support, but because the people that were from the start are still with us till the end as well. And because of that, we are very grateful for them. So first of all, as we always said in the previous questions as well, we are very grateful and extremely lucky to have our team advisors with us. And alongside our team advisors, we also have a professor of ours, Professor George, who has been an immense help to us, who has made our delivery styles and all of us improve on it. And it has been a very wonderful experience working with the four of them. And apart from the core team, I would say that we also owe our immense gratitude to our institution for giving us their support whenever we needed adjustments in our schedule and such. And specifically the student department, then I would love it if my team members can continue the list of people that we feel immensely grateful for.
First of all, similar to what my senior said, we have so many people to be grateful towards. Like she mentioned, our team advisors, our Professor George, and even the institution itself. And then, in addition to that, we have our friends and families to be grateful to as well, because when things were taking kind of a toll on us, they were very supportive. They were very supportive of us, and even our team advisors as well. They were very understanding and supportive. And like she mentioned, the institution was also very considerate of our schedule despite our other school obligations as well. So maybe I'll have my senior continue.
I don't think I could possibly add on to what they've already listed. I think, like they've both mentioned, these are the people that we're very grateful to, and we're always very not only grateful, but we really recognize the fact how much they've helped us and how much they've actually given their time for us. And as always, we're very, very, very grateful for that. Thank you.
Shout out to our Moot Court Society for giving us this wonderful opportunity. Thank you.
Thank you very much. It's lovely shout outs, and again, really well done, everyone. For the University of Nairobi, same question. How or whom would you like to thank for supporting your journey in the competition so far, and how has their support been meaningful or impactful?
Yeah. Yeah, so first and foremost, I would like to thank our gracious hosts from round one till now. It's been great interacting with you guys all the time. So it's always good to see you. So thank you guys. You're doing a great job. This is probably not as easy as many people would think. So yeah, kudos. Secondly, our school admin, especially our dean from law school, Professor Winnie. I do have WhatsApp conversations with her, or fairly brief one-on-one conversations, and she asks about how we're doing, and she's always been supportive. So uh thanks to them. Yeah, I would also like to thank these guys, my teammates. Yeah, they are great, hardworking, brilliant people, and it's been fun engaging and bonding with them across this experience. Yeah, I would like to thank them for coming over. We made the resolution in the out rounds to be a bit more tight and prepared together and not in isolated rooms. So yeah, they've always come over. So we're currently at my house. So that's been fun as well. Yeah, so thank you to these guys as well. I think that's it for me.
Yeah, so for me, it's not anything different. I'd say, firstly, I just want to thank you guys because I remember last week I reached out. We had a hitch with an examination timetable, and it has not been easy. We even have exams tomorrow, but it's the fact that you guys made the time to accommodate us. I think that was very important, and we really appreciate you. Then also to our parents, personally, my parents, they've been very supportive. They've always kept up with how the tournament is going, always making sure that we're okay. And most importantly, still to my teammates, we've been a group of three since the start till finish. We've not had a coach. We've just been depending on ourselves, training ourselves, learning by ourselves. And I think that's a really amazing project that we've worked on, a second one. And I think that's just one of the most amazing milestones that we've made, especially making semifinals. It's not easy, but yeah, it's been a nice run, and that's all. So thank you.
I genuinely don't have anything to add to what my teammates have said because it was very comprehensive. but just to extend the thanks from the organizing committee also to the opposing team, because I'm sure you had to consent to us moving the dates around. So this is very gracious on your part in terms of accommodating us. We know that we needed to have had this round last week, but thank you for accommodating our request and allowing us to have this interaction and debate today. So whatever the result is, this was, I think, something that we really appreciated in light of what was happening over here. So thank you to the opposing team, and thank you again also to the organizing committee and everybody involved in this for facilitating this transition and this accommodation for us. And just to echo my partners, thank you to our parents, thank you to all of our institutions, because we would not be here without them. So yeah, I just hope everything goes well from here on. Yeah, thank you.
Very much. It's honestly, it's been an honor to see your journey and to see the impact it has had on your growth as young professionals. So we look forward really to the next matches, as well as to your next steps in your careers. And on that note, I'm passing to Professor Levange for the conclusions.
Yes, sorry, it was a very, very nice match to watch, and we can see that is a semi-final, a real one, with as well as good interaction, and we can see that you had already many match behind, and so again, congratulations for reaching already this level. Being in semi-final means as well you will have an additional match, whatever is the result of this one, because either you will be in the grand final, either you will be in the match for the third place. So it means we'll hear you again against another team. So we hope to see you maybe live as well. Not maybe only next week, but during the next weeks and months if you happen to be in The Hague. So in any case, that is a real pleasure to see a debate and as well to see your paths as well during the whole competition. So many thanks again, congratulations, and again many thanks to the judge. And during the next days, of course, we will release the results. So well done again, many thanks, and wish you a great rest of the week. Congratulations again. Thank you.